Good morning, folks. I'm attorney Roger P. Foley. Yesterday I had a gentleman call me who had found me on the YouTube page, and he had a case that was recently dismissed. It was a case that he was arrested for. I think it was some battery charges, and ultimately the state declined to go forward. They declined to file on the case, which in the state of Florida is referred to as a no information. No information usually says that we as the state of Florida are not likely to sustain a conviction for the following reasons. It doesn't always say that, but a lot of times it'll say a witness is not cooperative, or the evidence is weak, or eyewitnesses gave a different version, and you're like, yay, me! The case is dismissed. And I get this call a lot, so I figured, why not make a video? So your case is dismissed. You have not even entered the courtroom but for your first appearance, meaning the day you got arrested, you went in front of the judge the very next morning and a bond was set. Sometimes you may not even have done that if it was a scheduled bond, meaning that if it was a bond where they ROR you automatically, or a DUI where maybe the bond is $1,000. Palm Beach, I think it used to be $2,000 or $3,000. Now I think it's ROR on a first offense. So you may not have even gone to court. You may have gone to jail, sat there for several hours, and then been released. So your case is dismissed, and you think it's gone. Well, guess what, folks? It's not. If your case is declined, if you receive a no information and the state does not go forward on your case, then you still have a record. Now, here's some good news and here's some bad news. The good news, if you have no prior criminal history, no prior convictions, or you have some history but there's no convictions, then if your case was no information, it was declined, then you are eligible to expunge your record. And you can go on the website and take a look at the information and see how long that process is, but roughly it's 8 months to a year. I usually tell people 10 months to a year because that's what it seems like it usually takes these days. And you hire an attorney and you go get your record expunged. It's a long process. If, however, you have prior criminal history, that includes a prior adjudication, a finding of guilt, where you've received time served, or an adjudication and you did some jail time or some prison time, or if you've just been adjudicated. Sometimes I'll see, and this is a common charge, I'm going to tell you about this, and I'm real careful never to allow it to happen to my clients. Someone gets charged for drugs. I don't know where the state attorney's office learned this. I don't know where the practice comes, but let's say you have someone who's got, I don't know, it could be possession of cocaine, it could be possession of heroin, it could be possession of ecstasy, but they have some type of paraphernalia with them. Could be wrappings, baggies, scale, whatever. A lot of times, and it's not just Broward, Palm Beach, Martin, St. Lucie, where I'm generally are, but I mean, I've been Okeechobee, on the other side of the state over near Tampa. I've been up north, I've been in Hendry County, and the state attorney will offer a withhold of adjudication, right? On the first case means you're not a convicted felon. For immigration purposes, it's considered a conviction. For scoring purposes, it's considered a conviction. But do you lose your license? Nope. You don't lose your driver's license. You don't lose your right to vote, and you don't lose your right to bear arms. Well, depending on the type of case. So So they'll offer that withhold of adjudication on the bigger charge, right? The possession of cocaine or heroin or ecstasy. But on the paraphernalia, they will offer an adjudication, time served, adjudication court cost, adjudication probation, whatever the case. When you see the word adjudication in any criminal case, right? If you see the word adjudication, not withhold of adjudication, but adjudication, that pretty much means that it's going to, your criminal charges are going to come up time after time after time because it's on your record for life. If you are adjudicated, it is on your record for life. You can't seal, you can't expunge. So, ladies and gentlemen, if your attorney walks over to you and says, "Oh man, I did great, yay me, and I got you 2 years of probation, and on the first count, and an adjudication on the second count of paraphernalia," what does that mean? It means they didn't do that great of a job. They need to convince the prosecutor, go back and get a withhold, because it might as well be a conviction, because you can't seal it, and then you can't wait 10 years and expunge it. Just so you know, just quick aside, if you receive a withhold of adjudication on most charges, go to our website and check out the charges in Florida that are not eligible, because there are certain types of cases where if you receive a withhold of adjudication, right? Let's say you get a withhold of adjudication on a domestic battery. Well, you can't seal it, and that means you can't expunge it. That means it's there forever. Certain charges you can't seal or expunge. Well, you can expunge everything if you got the case dismissed outright. As crazy as it sounds, if you win a trial, you can't. I don't know the logic on that, never will. And yeah. So, if you receive a withhold of adjudication and an adjudication, I don't want to say you're screwed, because depending on your facts, it may be a good resolution, but generally you're screwed. Because if it's always there, and every time someone does a background check for you to rent an apartment, lease an apartment, get a job, what's the sense, right? Like, the whole goal is to put it behind you, right? Because in our system, time served doesn't mean that it's behind you. Time served means you're convicted and it's going to sit there. And unless you open your own business, a convicted felon will have a lot of difficulty getting a job. Now, I'm sure there's some of you that'll say, "Hey, no, I'm a convicted felon and I got a great job. God bless you." Because I can't tell you how many people call my office searching for a sealing or an expungement of records. And it's impossible because they've been convicted. So unless you know the governor or the president, and I don't know either, that's your situation. So if your case is dismissed by the state attorney's office via a declining of charges, a no information, you want to expunge that as quickly as possible. Now look, I think I had a guy recently that called me and he had an expired tag. An expired tag. Like, it's a glorified traffic ticket. And he says, I want to get this expunged. And I go, okay, I mean, I'll do it, but I probably wouldn't waste the money to do it. I mean, you're roughly spending, $1,500 to $2,000 to get your record expunged. If someone got a dismissal of a failure to register, they got a TC, but it got dismissed. Would I really even bother? I wouldn't. Me personally, if it was me, if it was my family member, I'd go, look, no one's holding that. Like, it's a glorified traffic ticket. Now, granted, it is misdemeanor. It is a second-degree misdemeanor, but no one's going to stop and go, he just can't do this job at Home Depot or wherever, at the mall or whatever, because, or you know what, he can't become the governor because he's got a traffic criminal citation, a misdemeanor. I wouldn't worry about that, folks. So don't get overly down on yourself if you forgot to register your tag. The crazy thing was, on that case, the guy's tag was the same month, so the cop was just dumb, or not dumb. Maybe he was just trying to break his chops for one reason or another, because you usually don't even get that citation unless it's 4 months or over. So I really didn't even understand it, because as soon as the guy went to court and he had registered his car the next day or whatever, it was dismissed. So anyway, I'm attorney Roger P. Foley. I wanted to share that bit of information. Take care. Subscribe.